So the struggle over ending cash bail in California has become a little like something out of Game of Thrones, with a lot of armies, on the field, and a lot of fields of contention, fields of battle at the same time. You've got legislation was passed by the legislature, signed by Governor Jerry Brown, but now there is litigation, which we're going to talk about in a minute. There's also a ballot initiative from the bail industry to overturn it, which may have the effect of freezing it over the next 2 years. Let's go back to basics. Mr. Bonta, you were one of the sponsors. What prompted the passage of the legislation in the first place? What were you hoping to achieve?
Fixing a major injustice, unfairness, inequity in our criminal justice system. And there are many, but this was a huge one. And the multi-front war you talk about is because it's such a transformational, paradigm-shifting change. Change is hard, and we're pushing for a more just system, but it always comes back to people for me. In what I do as a legislature and the way the criminal justice system impacts people. It was the folks who lost their job because they didn't have enough money to pay their bail and could definitely be safely released, or they lost their cars or their kids or their homes. And that was wrong. And I wanted to end the anguish and end the suffering and create a better system. And we're the first state in the nation to completely end money bail. That's huge. We're the biggest, most diverse state. And we have something to build on. And we're on a continuum now, moving from good aspiring towards perfect, and we need to continue to improve the replacement system. But ending money bail and putting it in our rearview mirror is a tremendous step forward.
Chesa, as we said, the bill was passed by a predominantly Democratic legislature, signed by Governor Jerry Brown, praised at the moment of that signing by the incoming governor, Gavin Newsom, also a Democrat. But you have said, quote, the new SB 10 doesn't actually change the racist system of mass incarceration. It just expands it. Where, in your view, did they go wrong?
Well, let me start by thanking Assemblyman Bonta for his leadership on this issue. I think he's absolutely right that SB 10 is a major step forward, but the details matter tremendously. And our concern has been and continues to be with how the bill is implemented and with some of the potential pitfalls that it creates. The problem with money bail at its core is that it allows the criminal system to coerce guilty pleas from poor people, primarily people of color. And that undermines the integrity of the entire criminal system. We're trying to put the justice back in the criminal justice system. And I think this bill can help us do it. But we need to make sure that the way it's implemented actually increases public safety and releases of people who can safely be released.
But when you say or have said that in your view it expands the system of racist mass incarceration, in what way does it do that? What has to be changed?
Well, the bill on its face would seem to allow detention of anybody, regardless of their criminal history and regardless of the charges that they are arrested for. Now, it may be, and this is my sincere hope, that our litigation and our partnerships with Assemblyman Bonta and with the Judicial Council and others will ensure the way the bill is implemented, certainly in places like San Francisco, but across the state, actually has the opposite effect. But I think that's a fight we need to continue having.
So, Judge, you were part of the pretrial detention reform work group that was involved in this. That issue of the level of discretion for judges to order pretrial detention is right at the heart of this debate. What were you trying to achieve, and what is your view about the concerns that Chesa and others have raised?
Understood. First, I'd like to also thank the Assemblyman for being the laboring oar on this, because it is true. Cash bail does not mean safety. Cash bail hurts the poor. I remember when I was on the work group, just real quick, just in a six-month snapshot in Santa Clara County, they determined $500,000 non-refundable monies paid by the people that, and the cases weren't even charged. So they didn't get their money back. But guess who did? Who kept the money? So that is wrong. And you know, it's an evolution. I've been a judge for over 16 and a half years. I have been a lawyer, yes, when I started at age 12 for 40 years. But what the concerns are, and which I really applaud, is SB 10 starts off with the following. that we have to look at cases individually versus the charges. You know, we have this scale or this bail schedule that says if you are first-degree residential burglary, bail is at $50,000. SB 10 forces judges to look at cases, each case that is charged that comes before it on a case-by-case basis. I have to disagree respectfully that it starts off with all misdemeanor charges, with the exception of a few. They get released immediately. They don't even have to come to the judge. They get a cite, and they give an appearance date, and they get released. Minimum risk doesn't automatically mean incarceration or detention. They go through a process where if they meet the requirements that they're going to appear and that they are not a public safety, the pretrial release program will release them. And we are now coming up with, and we're going to start talking, each court has to talk with its justice partners. Now, the serious felonies or the serious cases such as murder, rape, domestic violence, assault with a deadly weapon, again, those are serious where they come before the court. And they're not automatically detained because now under SB 10, which I think is great, is that the court, the judge, now has to hear the evidence and deal with each case on a case-by-case basis. And then only and on clear and convincing evidence, which is not the standard that's being used, but clear convincing evidence, does a judge detain a person, but you have to state it on the record that this person is a flight risk, a danger to the community, and releasing them back into the community is not an option. That's going to put a high standard, more work, which I know my colleagues are going to say, I can't believe she's saying this, more work for the judges, but that's what we're there for, to make decisions on a case-by-case basis and make that standard on a clear, convincing versus a bail schedule. So that's why I applaud SB 10.
Sarah, I think you're a little like the friend who's been invited to Thanksgiving dinner without a history, without being part of all the history of family disputes that go back for years. So let me, you're kind of like watching all of it. So let me ask you, what do you make of what California has done, and how does it compare to the thinking that's underway in other jurisdictions around the country?
Well, I think that it's really driving our national narrative, actually. So we're seeing bail reform going on in every single state, and just about every single state also has jurisdictions that are engaging in the implementation of pretrial risk assessment tools. I think it's just that the level of attention and the state kind of driven initiative here in California is on a scale that's really different than every other state that I've worked with or that I've known about. Some states are doing it where they're saying, this is the tool we're all going to use, and we do it that way. Other states are letting jurisdictions kind of do their own thing and come up with kind of working groups about guidance at a state level without putting legislation into place. So I think it's actually just very much in keeping with what's going on, but it certainly is what everybody is talking about, even in all the other states. So I live in North Carolina, and people are constantly asking me about what I think is going to happen with SB 10.
So just to follow up, the places that have moved in this direction, DC, for example, the DC court system, what would you say are there lessons that are applicable to California, or is California just so much bigger that they can't really learn much from looking at what other places have done?
Well, I'm a professor and a scientist, so I think we can always learn something. But those states, I think, that have done it, or jurisdictions that have done it, there are definitely lessons to learn. And I think one thing that I really liked about the legislation as I was reading it here is the importance of implementation and validation studies. So looking at whether or not the tools that are being used are actually doing the thing that they ought to be doing. I also think that the importance of having guidelines around what the results of these tools mean is really important, and to remember that the tools themselves are a piece of evidence that go in front of the judge. It is not the final decision, and it was never designed in that way. Whatever tool you're looking at, it was really just about providing some scientific evidence that might suggest what this person might behave like in the future.
But let's file the tools away and come back to them in a minute, because that is worthy of a extended block of conversation. But let me go back to our Game of Thrones analogy. One of the armies on the field trying to overturn the law is the referendum. And it appears likely that will be certified sometime very soon. and will be on the ballot in 2020. What will it? I assume, as you oppose that, does anybody on the panel support the referendum? First,
I can't as a judge.
As judge.
No, absolutely not.
And even though you're challenging the law in court in the Humphrey case, you oppose the referendum.
Yeah, just to be clear, the Humphrey case predates SB 10.
And it's now kind of incorporated it, though.
Right. I think the Humphrey case will be critically important in determining how SB 10 gets implemented, and it will provide judges across the state with guidance on what limits there are to their discretion under SB 10. And we're waiting to have an oral argument scheduled in the Humphrey case. It's been fully briefed. And actually, the final version of SB 10 that was enacted specifically says at the very beginning that it is to be interpreted in accordance with the Court of Appeal and Supreme Court opinions.
Just to be clear, though, so your office opposes the referendum?
Correct.
Yeah. What will it take to beat the referendum?
Getting the message out, money, resources. I mean, it's a statewide communication strategy. So getting the right coalition together, the governor-elect, some of the key stakeholders that help us get SB 10 over the finish line and others. But we've seen, we're getting a sense of what those behind the referendum will do. They're telling exactly opposite messages to different audiences. They're telling some people the jailhouse doors are being thrown wide open and violent people are going to get out and they're going to hurt you. And then they're telling the opposite to other audiences, saying this is going to mass incarcerate more and more people, largely communities of color. They'll say whatever's necessary to try to continue a practice in an industry that hurts people. That's wrong, and we can't let the referendum pass.
I was going to ask you about that because obviously, as you know, to the end of the process, there were groups that have been traditional allies, certainly advocates of reform, who ended up, the ACLU and others, ended up opposing the final product.
Yeah.
How much of a complication is that kind of fissure in the ranks to beating the referendum? I mean, is there going to be an audience, in effect, on the reform side for repeal?
I think the differences of opinion around the final product of SB 10, it will not carry over to the referendum. I think everybody will strongly oppose the referendum. I do. And I've seen that so far. I mean, and, Chesa has reasonable concerns about SB 10, and we're talking about them. We're trying to fix them. He doesn't think the referendum should pass.
That's exactly right. I mean, we had our differences. We hoped that SB 10 could go further and do more. We had what I believe to be very legitimate concerns. Those concerns in no way suggest that the status quo, the racist, unjust money bail system, should be perpetuated. Everybody who seriously looks at these issues agrees that money bail has no role in the criminal justice system. The question is, what should replace it, and how do we get there? And that's something that, regardless of our disagreements, we can all agree we need to put our minds together and work together to solve.
And I look at SB 10 as a start, and it's the best start, and it's not perfect. No offense, but we're working on it, and it's going to be a trial and error. But it's very progressive. It's the first of its kind, and we're going to try to implement it after we deal with the referendum, and then we'll tweak it and make it that it is fair, and that's the goal of it.
Well, while the referendum, once the referendum qualifies, obviously it's frozen, right? SB 10 is frozen, and you cannot even change it in the legislature. You cannot do any of these changes between now and 2020. You cannot even can you reform the bill between now and 2020, or is that frozen as well while the referendum is pending?
We can make changes to SB 10.
You can?
Yeah, and we've proposed some already to help remove the bias from the risk assessment tools. Senator Hertzberg and I have that. There's also a process in the legislature where the referendum there's hearings on it, and there's a possibility for the legislature to have a role in shaping what the referendum looks like. There's a possibility for negotiation to get the referendum off the ballot. There's all sorts of possibilities going forward. But typically, yes, once it's qualified, there's the freezing. And this happened with the plastic bag ban, right? The plastic industry, as soon as the plastic bag ban applied statewide, qualified a referendum. It gave them another year of life in the implementation. It failed miserably in front of the voters, and that's the same result that I hope for here. Negotiations
with whom to get it off? Who would you negotiate with to have it removed from the ballot? The bail industry?
I mean, if there were to be negotiations, and look, I think they're going to be very hard to have negotiations with those behind the referendum. I'm just saying that's a possibility procedurally to do that. That's happened before with other ballot measures and referendum measures. So that is who it would be. It would be with those behind
Sarah, Assemblyman Bonta just raised the issue of the risk assessment tool. We heard about it before. Obviously, this is a question that comes up all around the country. Many reformers have advocated for this for years, but there's now, I think, growing concerns that it may kind of quantify the biases already built into the system. Where do you come out on that? And is there any innovative, what is the best thinking that you've seen about how to deal with those concerns without abandoning the tool altogether?
Sure. So I think the tools themselves, it's important to remember that they were designed to reduce bias in human decision making. That was the whole point of these tools. And I feel very strongly, and looking at the research evidence of what we have so far, that in fact they do that. So the use of these tools are going to be less biased than what we might see without the tools. Are they perfect? No. Are they eliminating racial bias? No. So I think what we need to do is keep studying the tools and identifying where they're not working and how and why, and looking at the content of the items and how that is put together to create these ultimate decisions.
Judge, I think if I'm correct about SB 10, it allows each county to choose its own tool. Is that right?
Yes and no.
Yes and no?
This is what's good about SB 10. They now charge our Judicial Council, which is the governing body for all the courts, all 58 courts in the state, that the Judicial Council now will have a list of tools that are the best. So it's not one size fits all. And it will ensure consistency, that at least these tools have all gone through some sort of vetting process to make sure that they're fair. And it eliminates, we had a situation that was reported in the paper where a jurisdiction was using a tool that was for post-conviction, not pre-conviction. And it was the wrong standard. So this, SB 10 now will have a list of those tools that they have found to try to meet this goal of minimizing any discrimination, economic, racial discrimination, and make it a more fair, and it's a instrument and a consideration for us to deal with at the time of arraignment. So that's one of the beauties of SB 10. It's going to have consistency among the state, and we'll have a list of tools that will be acceptable.
I just say, is anyone on the panel concerned that the level of flexibility will create different, in essence, rules for who gets held in jail based on the political climate in the different counties? Do you worry about that? Or?
I do, and I guess there's a couple points on that. The first one is that's where the Supreme Court's guidance and the Humphrey opinion is going to be critical.
Okay.
We need the Supreme Court to provide clear guidance on who is eligible for pretrial detention under what circumstances. We're litigating that issue. It's been well briefed, and the Supreme Court at some point this year will provide guidance on exactly what the limits on judicial discretion in the courtroom are. Let me say two other things about risk assessment tools. The first thing is that there's a critical role that they can play, a positive role, in providing judges with more empirical information to make difficult decisions on a short timeline. However, we need to be very clear about the limitations of these tools. And some of those are inherent in risk assessment, and some are particular to an individual tool. So, for example, we all know, it's undisputed, there's ample empirical evidence that the criminal justice system as it exists today is racist. We know that racism manifests at every stage of the process, at policing, at representation, at conviction, at sentencing, at reentry. So if the data we're using to feed into these risk assessment tools comes from the racist criminal justice system, then the tools cannot be said to be race neutral. Now, that's one problem. It doesn't mean we throw the baby out with the bathwater. Another problem is, and this is separate, that the tools are not simply giving judges empirical information. The way the tools are designed is that they make a lot of political decisions. So, for example, in San Francisco, we have a tool that has what's called a step 2 exclusion. What does that mean? It means that regardless of your empirical risk, you could be the lowest risk possible based on the data. If you are arrested and the police book you into jail on a particular charge that falls into a laundry list of charges, the tool will automatically recommend that you be detained. That's a political decision. It's not a risk assessment empirical decision. And we need to be clear in how we talk about this issue and how we sell it to the public about the distinction. There's a role for politics in this, of course. Judges every day are going to be charged with making decisions. But it's my view that because judges have the power and will continue to have the power to override the recommendation of these tools, that the tool should simply present judges with empirical data and not override that data with recommendations based on politics or charge-based detention.
And that is why we have SB 10, because that's where we get various tools. And yes, we have a tool that's being used in San Francisco, and I'm not thoroughly convinced that it was the best and be all, but I cannot wait to look at other tools to see if it works within our system. And understanding that it is just one factor, we still will hear the arguments, we still will look at the background, and we will still make those decisions based upon the facts, unlike what the bail schedule is, charge $50,000 versus let's now get into the facts.
Well, sir, I mean, the concerns that you hear are really from both directions, that SB 10 still leaves too much discretion in the hands of judges, and or from that the tools themselves are point toward the wrong outcomes. What's the third way? I mean, what's the path in between those two? And Chesa, maybe I can ask you as well. What is the path in between those two concerns? Is there one?
Well, that's a great question. I think we have to keep working on the tools. Most of the tools are open source. You can see the information that goes in them, and they just constantly need to be vetted and looked at. I would say that there is not a tool that I know or anybody that I work with who would say that the tools themselves should produce the ultimate decision. We really view it as, here's what we know about human behavior. Let us tell you about this and how that might relate to this person sitting in front of you, or more accurately, how this person sitting in front of you compares to the population upon which this tool was developed. So I don't know that there's an easy answer, but I certainly like the idea that individual jurisdictions can go through and through stakeholder processes and whatever that might look like, pick the tool that they feel like really works best for them. What I can tell you about the empirical evidence is that pretty much all the tools work pretty well. And so I get calls a lot about what tool should I use? What's the best tool? And we don't have that answer. It's really about matching, one of the list of tools of those that have acceptable validity, and then seeing which one would work in the jurisdiction, in the system that exists there.
I mean, I think the third way is the hybrid approach that SB 10 proposes. The use of risk assessment tools that are validated, that are as bias-free as possible, that are reliable as a tool to help inform a judge's decision. And then the judge doesn't have limitless discretion. It has guardrails, and there's standards, and there's guidance. So providing some discretion within parameters, with metes and bounds. And that's what we propose. And we have data feedback loops required so that we're getting studies and we're getting information and that suggests, I mean, it states that we don't think we have it exactly right yet. We need that data to make it perfect. But we think that, I vehemently agree with Chesa's point that there is bias and racism and discrimination all throughout the criminal justice system. So the question is not, are these perfect? Is the new system perfect? It's, does it make improvement? Is it better? Does it reduce risk? I mean, does it reduce the racism and discrimination? And I think it does.
Well, the handicap you're operating under is that you have no chance to prove that case once the referendum qualifies, right? I mean, you can't see this in practice between now and 2020.
Well, yes and no.
No?
A lot of I mean, we didn't recreate the wheel here. We looked at DC. We looked at Santa Clara. We looked at San Francisco. There's pockets of counties that are
Can counties do this on their own?
San Francisco has been doing this already for more than 2 years with really extraordinarily positive results. We've dramatically increased the number of people released from custody pre-trial and the speed with which they're released. And the safety rate, or the rate of reoffense, is lower than the tool developers predicted based on their national sample.
However, if I can just throw in, we are doing well, but it costs money. And unfortunately, we don't have the state funding to do it. And San Francisco, its court alone took a 10% cut. So how long we're able to do this? So that's why, because SB 10 comes with a mandate along with the funding to take care of all the courts.
I want to bring in the audience, but can I ask you real quick, so can counties, even if the state law is frozen until 2020, can counties end cash bail and in effect adopt SB 10 on their own or not?
I think they can. I mean, I think they can implement whatever.
We can't eliminate.
In counties. I mean, it would be tested in the courts. Right?
It's up to the judges of each county under state law to make a bail schedule.
Yeah.
The fact is, right now in San Francisco and every other county, that schedule is a monetary schedule. There's nothing that requires it be monetary. So I would encourage the judges right here in San Francisco and beyond to get ahead of the ball and start working on a bail schedule that's based on actual conditions related to public safety rather than arbitrary price tags on.
And do you think those, if some of the large counties in the state made those changes before 2020, would that increase your chances of protecting the law and defeating the referendum?
If more counties implemented?
Yeah, yeah. On their own.
I think the more demonstrations of success, the better. And what we have already shows success, but if there were more, that would help.
Let's go to the audience. Anybody? Yes. Over here.
Good morning. I'm Jonathan Mays, and I'm the SVP for External Affairs, also Chief Diversity Officer for Albertsons Companies and Safeway. Assemblyman Bonta, great to see you again. I commend you on the legislation.
Thank you.
Thank you.
Judge Jackson, we've talked a little bit about the reality of, frankly, bias, and I wonder if you could just comment a little bit about what's being done with regard to training of judges to try to minimize the impact of bias.
Good question. I'm the presiding judge of San Francisco, and I end that. No, December 31st at 11:59, it's done.
Who's counting?
I'm not counting. No, but in my tenure, and I've been in the administration as the assistant PJ and now the PJ, and it has happened before. We are doing mandatory training under my watch, and we just completed 3 courses that were 2.5 hours on dealing with unconscious bias in the courtroom, in terms of how you handle cases, in terms of how you sentence cases, and even in civil cases. So I really applaud that we are getting trained, and we shall continue to be trained. And we even had a training just a month ago in domestic violence, not just in criminal, but being able to recognize domestic violence in civil cases. And how do you handle it? Do you just, well, this is a contract case and I'm not even going to look at it, or what are our responsibilities? So I really think that's a great question, and we will continue to do this so long as I'm a judge. And in fact, San Francisco is considered the model that other courts have asked about our training programs. So thank you.
Thank you.
All right.
Thank you.
All right, we have a...
Yes, my name is Gloria Berry, founder of Berry Powerful Ladies. I worked in law enforcement for 8 years, and when I was in the academy, I was trained when you booked a person to put as many charges as possible in hopes that one would stick. So my question is, when you have these tools to determine bail, are the charges that you know are stacked against the person used in the criteria as a tool?
Yes, and the answer is that continues to be a problem under the risk assessment tools that we're using in San Francisco and that are proposed across the state. So the exclusions or the automatic detention recommendations that I referenced earlier are based on the charge the police officer decides to put on that person. And one of the concerns that we've expressed and will continue to express is that there's absolutely no feedback mechanism or check on the discretion of those officers. Because if they decide to book somebody who's arrested for simple possession of drugs on attempted murder, even though there's no evidence whatsoever of any physical violence, then the tool as used in San Francisco will automatically recommend detention, regardless of what the district attorney says when they look at the evidence. That's a problem.
One thing I will address on this issue is called stacking, and that was one of my issues as a presiding judge, and I worked with the sheriff, Vicki Hennessy, that they will no longer stack the bail. So they may have 7 charges. They have to figure out what is the primary charge, and that is the bail. So you don't have what was supposed to be maybe $10,000, but because there's 7 arrests or 7 charges, that it turns up to be $70,000. So we have worked in that direction, not necessarily with the tool, but that was a problem. It was a concern when I became presiding judge about stacking at the time of booking.
Sarah, any final thoughts?
I would just add that, first of all, there are lots of different tools, and most of them do include current charges as one of the items. But the other thing that I would say about that is that there's usually, 8 to 10 items total. So one item in and of itself might not be damning. And that this is the kind of thing that we who do the research in the area would want to look at and be able to tease apart and play with to see how we can eliminate those implications of bias in the tool itself.
Right.
I mean, I just say we're at a really, really critical juncture right now. It's an exciting opportunity to make our criminal justice system more just. No longer will the jailhouse door swing open or close based on how much money you have in your pocket. No longer is liberty pay to play. No longer will people be their liberty be decided based on the size of their wallet. It'll be based on the size of their risk, and that's important. And I always think about people and the impact that it has on human beings. And I think of someone who I worked with on this issue named Otto Walker, who had a charge against him that he vehemently disputed. It was ultimately dropped, but his mother had to take money out of her own retirement to pay for his bail. And he got out because he was the sole breadwinner for his family, but he suffered endlessly because they were in a cycle and spiral of debt. And that's wrong, and we're ending that.
Well, this audience, you've digested a lot of policy this morning, and I commend you on your stamina. But I think next we have something a little more expansive for you. So I'm going to join me in thanking this terrific panel. And now we're going to welcome on all the world to stage. Thank you.
Thank you. Good to see you.